Welcome back. In this subunit, we're going to discuss equitable remedies for contract breach. We're only going to cover the most important concepts in equitable remedies for contract breach. The first most important concept is money damages. Legal damages is the preferred remedy, and that you can only get specific performance for contract breach in a very limited number of circumstances. We're not going to cover all those circumstances, but we're going to cover the most important circumstances, and this is how I like to remember them. You can get specific performance if the contract involves real estate, the Mona Lisa, Elvis, or non-competes, right? And in all of those circumstances, if you want specific performance, you have to go to the court with clean hands. This is an equitable remedy. Courts consider this an extreme remedy to force someone to do something. And therefore, if you are the plaintiff in this case, you have to be as white as the driven snow if you're asking for equitable remedies. All right, so let's just take a quick look at these. Real estate. Contract for the sale of real estate. Either buyer or seller can get equitable performance if the other party breaches the contract. Sale of the Mona Lisa, unique goods. If I contract to buy the Mona Lisa from you and you don't deliver, I can get specific performance. I could also sue for money damages, but I would prefer specific performance. I want the Mona Lisa. If I hire Elvis to perform and Elvis breaches the contract, here's the thing. I can't get specific performance in the sense that the court will not force Elvis to perform under the contract. But I might be able to get a negative injunction where the court would prevent Elvis from performing under another contract during the same time period as our contract. More on that later. And then non-competes. We talked about non-competition agreements. Courts will specifically enforce them. All right, here is the general law about whether equitable remedies will be available, right? A court will grant an aggrieved party an equitable remedy only when legal remedies will be inadequate. Why would legal remedies be inadequate? Well, there are three basic situations. Damages are difficult to prove. We've seen situations where it's difficult for the party to prove what her expectation damages would be. There are also situations where the object of the contract is difficult to value, especially if it involves some sort of heirloom or priceless work of art. A court will also grant specific performance if there is difficulty for the aggrieved party to obtain substitute performance. Finally, a court might grant the aggrieved party specific performance when the aggrieved party will have difficulty collecting damages from the breaching party. Normally, when the breaching party is insolvent and would not be able to pay damages. Under those circumstances, the court might grant specific performance. All right, we already talked about these defenses. So if you sue me for specific performance, I might come and I might say to the court that the court should not grant specific performance because you, the plaintiff, do not have clean hands. And the idea of clean hands, as I just mentioned before, if you are asking the court for an equitable remedy, you're asking the court to do fairness. This is an extreme remedy. Money damages are preferred. But if you're asking the court to do equity, you have to come to the court as pure as the driven snow. You can't have any fault on your part. And if you look at what clean hands encompasses, that the contract must be definite, that there must be consideration, there must be no unfairness. We'll look for impossibility, impracticability, frustration of purpose. We'll look for whether enforcement of the contract creates disproportionate hardship, injustice, or forfeiture. And we'll also look to see if you delayed suing under the contract. Now that's the concept of laches. Laches is an equitable concept. You're familiar with the idea of a statute of limitations, that if you don't sue within a certain period of time, and usually for contract it's 6 years under the common law, 4 years under the UCC. If you don't sue within 6 years or 4 years, then you lose your lawsuit. Well, laches is an equitable doctrine, and laches just says if you have waited too long, that's it, just too long to bring your lawsuit for an equitable remedy, then we will not enforce it. So all of those defenses, you might say, well, we talked about definiteness and consideration already. How is it different here? Now it's a heightened scrutiny. So before, when we talked about definiteness and we talked about reasonably certain terms, we were talking about situations where there's breach and money damages. Here, now when you're asking for equitable remedies, the court's going to be a little bit stricter. The court's going to ask for more certainty than they would if you were suing for money damages. Same for consideration. Remember when we talked about consideration? We said that the court will never look into the adequacy of the consideration unless it's sham. The court will not say, ooh, this is an unequal bargain, so I'm not going to enforce it. That's when you were seeking money damages. If now you're seeking specific performance and the court says, this looks like an unequal bargain, it looks like the consideration is not adequate, now maybe the court will not grant you your equitable remedies, where under the same circumstances the court would indeed grant you money damages. All right, let's look at each of the situations in turn. First, let's look at the real estate contract. Simply put, that the contracts for the sale of real estate, if one of the parties is in breach, whether it's the buyer or the seller, the other party can always, almost always, get specific performance. Why? Because each plot of land is thought to be unique. And therefore, because this plot of land is unique, it is difficult for me to go out and find substitute performance if you, the seller, breaches the contract. Or, same thing, if you, the buyer, breaches the contract, this thing is unique, it is difficult for me to go out and find another buyer. All right, let's talk about personal services. We talked about Elvis. Now, for personal services, we won't get affirmative injunctions. What does an affirmative injunction mean? It means that the court will not require the breaching party to perform. So I hire Elvis to perform for me on a specific night, October 12th, and Elvis breaches the contract. I cannot go to court and ask the court to force Elvis to perform this contract. What I might be able to get is I might be able to get a negative injunction where the court will say, okay, Elvis, you breached this contract. We're not going to make you perform this contract, but we're going to prevent you from entering into any other contract to perform that night. Now, I, the aggrieved party, I'm only going to get this remedy if the personal services contract was unique and extraordinary. And we're talking about an entertainer. We're talking about a brilliant scientist, right? You have to make the argument that the services were unique and extraordinary. All right? The test for unique and extraordinary is there a reasonably equivalent substitute available? Let's talk about another situation where we have a non-compete agreement. We already talked about non-compete agreements. We said a court will enforce a non-compete agreement if it's reasonable with respect to scope, duration, and geography. The question is, can I get, if I'm the employer, can I get specific performance? And the answer is yes, because you're asking the court for a negative injunction. You're asking the court to prevent the employee from working someplace else in breach of the non-compete agreement. For the non-compete agreements, the services do not have to be unique and extraordinary. Let's talk about the UCC approach to specific performance. There are two important provisions of the UCC that you need to learn. I'm just going to go over the basics here. You should go out and read them on your own and come to an understanding of them on your own. The first provision is 2-716, and 2-716 says that a buyer, the aggrieved buyer, can get specific performance from the breaching seller in the case of unique goods. We've already talked about this. This is the case of the Mona Lisa. The Mona Lisa is a unique good, and therefore, if the seller breaches the contract, the buyer can get specific performance. The court will force seller to actually sell and deliver the Mona Lisa under the original terms of the contract. The other situation where a buyer can get specific performance is where the goods are not unique, but under other proper circumstances. What is other proper circumstances? Well, other proper circumstances probably means it is difficult for the aggrieved buyer to cover. Remember what cover means? Cover means that the buyer goes out and finds a substitute source of the goods when the seller is in breach. So when would it be difficult for me to cover? Well, it might be difficult for me to cover when the goods aren't unique, but they are still sufficiently rare, that it will be difficult for me to find those substitute goods. There's another circumstance where it will be difficult for me to cover. So we have a contract price, and then I have to go out and cover, and the cover price is just substantially greater than the contract price, right? Then it is difficult for me to cover. The UCC also says that buyer can replevin identified goods to the contract if she cannot cover or it would be fruitless to try. So that's the same idea, except it uses the word replevin. What does replevin mean? Well, unfortunately, replevin isn't really an equitable remedy, even though it's forcing the seller to deliver the goods. It's an old common law legal remedy, and you might say, well, it really looks like specific performance. That's what I think also, so that's why I included it here. The next provision you have to read and understand in the UCC is 2-502. And 2-502 covers a specific situation. And we look at 1, 2, 3, and I'm going to look down and read it because I don't have it memorized. Buyer gets to recover goods from the seller when the seller is in breach if the goods are identified to the contract and the buyer has already made part payment for the goods. The buyer tenders the remaining payment, right, whatever is due under the contract, and the goods are for household or family use, or the seller becomes insolvent, right? So if I am buying a refrigerator for my house and I have put down a down payment and the seller breaches the contract, I can recover that refrigerator if it has been identified to the contract, which when we're talking about refrigerators, maybe not, but if it was a floor model, yes, right? If I go, the floor model is identified to the contract. I have made part payment, right? I said I put down a down payment. I go to the seller and I tender the remaining amount. I can recover those goods. Why? Because the goods are for household use. If the goods are not for household use and I meet all of the other conditions, I can still recover the good if the seller has become insolvent.